indicate that they take the view that only if the court finds that the lower court was wrong, i.e. misdirected itself, that your Lordship can interfere. We say the balance of the wisdom is, as per the Mohammed case, namely you have a wide discretion. But the real point I'm making in referring to the state's heads, which are extremely brief, is that the state then, taking the attitude that you have to find an error on the part of the magistrate before you can interfere, which we say is wrong, then don't defend the magistrate's judgment at all. We have detailed grounds of appeal, which are in the notice of appeal, at page, your Lordship would know where it is, but it's at page 0061. The magistrate gives no further reasons, no additional reasons. So in the face of, let me call it, trenchant criticism of his finding, he says, I've got nothing to add. And we point out sharply, respectfully of course, but sharply, the various errors he makes. The point I try to make is that the state just say, no, this man mustn't get bail. But they don't defend the judgment of the magistrate. They don't deal with the grounds of appeal. Now, I'd like to deal, with your Lordship's leave, with the errors made by the court in its reasoning, because of two reasons. Firstly, you've got an absolute discretion anyway, but insofar as you are guided, if that's the word, by the magistrate's judgment, we will show you that that magistrate had material faults in it, which unfortunately bent his mind in the judicial sense towards refusing bail, when many of the facts he found and conclusions he reached were unjustified by the papers. So the point I make is then twofold. Number one, you've got an absolute discretion. Number two, to the extent that you're guided by the magistrate's reasoning, it was wrong. And thirdly, the state doesn't appear, and importantly, doesn't appear to defend the magistrate's reasoning. It just says, no, serious case, you've read it, it's very short, and bail should be refused. Now let me, because that's the heart of the case, the balance of the heads of argument deal with the test of the test for bail, the constitutional right to freedom of movement, etc., and the various approaches by the law, which I'll come to at the end. But let's go to the heart, and it's in paragraph 60 of our heads, page 00821. We set out that we go to page 62, paragraph 62, we set out the first ground of appeal. But before I go there, with your leave, one overriding fact which the magistrate substantially ignores, and which is fundamental and foundational to why the magistrate was wrong, is that it's common cause that the appellant was arrested on a charge of murder, refused bail in the Vereniging Regional Court, granted bail on appeal by His Lordship Mr. Acting Judge President Ledwaba, he finding that there were exceptional circumstances warranting the release of the accused on bail. The magistrate takes the attitude, yeah, that's a different case, it's not binding on me. Of course it's not binding on him in the judicial precedent sense of the word, but it should have been highly persuasive, because only 3 weeks later is the same accused arrested, okay, this time on 3 further counts of murder. But he had abided by his bail conditions. He was arrested at home, in his home in Sandhurst, Tanton. He had not done anything to indicate that he was a flight risk, would bring the bail system into disrepute, to interfere with state witnesses. Nothing that could disqualify him for bail took place or was done by him. And yet 3 weeks later he's arrested and he's denied bail by the court in Alexandra. We say that's an overridingly important factor which the magistrate to a large extent ignored and which your lordship will take into account, I emphasize, not bound by Judge Ledwaba's finding, but we submit guided by that finding. Now, what's the difference between then and now? The difference between then and now is there 3 further charges of murder, premeditated murder. And what's the sentence for premeditated murder? Life imprisonment. What has the accused done? Facing life imprisonment, released on bail. He lived at home, didn't interfere with anyone, didn't try to run away, did nothing to bring the bail system into disrepute. The offences, the killings, the murders took place some time ago, and he's just remained at home since his release on bail and prior to being arrested on the first count, where if Judge Ledwaba is correct, and he was correct within the facts of that case, he should have run away before being arrested on the first count.
Mr. Hillen, sorry to interrupt, but whilst we're dealing with the original, let's call it the original, and
Yeah.
I think that was referred to in the Vereniging
Yes.
counts, yes. Could we just, the charge sheet as it stands at present, does that consist of, and what is it made up of, and has that count, or have those counts, with the murder in respect, is that in respect to Mr. Buthelezi?
No, Armand Swart is the Vereniging matter, and that now remains count 1 in this matter, to which is added 3 more counts of murder. There are also counts of conspiracy to murder,
Yes.
and then there are counts of possession of firearms which don't relate to this appellant.
Where will I find the charge sheet as it stands? Because I just had some, I'm sure it's clear to the parties, but to the court had some.
It's page 0021-19.
Hmm? 002-119. Is that?
My learned attorney.
I can give assistance, my lord, if
Thank you.
to starting from 3 there.
Yeah. My attorney reminds me that this case doesn't include the Armand Swart case. So I was wrong. This is the 3 further murders and conspiracies to murder, but in the background there's another one. But they will be consolidated in the Palm Ridge High Court. So he is facing 4 charges of murder, but 3 are in this indictment and 1 is existing.
Yes.
But the 2...
So
the
I'm just
2
referring to your heads of argument. So just to be correct, that's at paragraph 5. Got the second arrest, but we've got, if we can consolidate the murders with the conspiracies to murders, we've got 1, 2, 3, 4. And you say the Vereniging one is not in this.
There are 3 murders. There are 3 murders in this one. The Vereniging one is a separate indictment, which is the judgment of Judge Ledwaba emanating in the Vereniging court. But why I said there were 4 is that it's intended these indictments be consolidated into one charge.
Yes. But I've still got one. I've still got one too many.
Well, there's...
If we look at again, paragraph 5, so we've got Seforka is 1.
Yeah, you forget for the moment the conspiracy, although I don't say it's not there, but
Yes,
count 2 is murder of Seforka.
Yes.
That's DJ somebody.
So I'm saying if we bracket the 2, so counts 1 and count 2 are together. So if we just look at the names of the deceased, so we've got
Yes.
Seforka's 1,
And then
Mfena's 2,
and 4.
Mayeza's 3, and Butelezi's 4. And then we've got Vereniging, which is 5.
Yes, no, you're quite right.
Yeah.
No, you're quite right. So it's not 4, it's 5.
It's 5.
Yeah. No. But the point I was making, perversely being wrong, is that when you're facing life imprisonment,
Yes, I'm.
You only have one life, my lord. And if you don't run away from one life imprisonment, you're not going to run away from 3 or 4 or 5 life imprisonments, because you can only serve one life imprisonment. And then I'll get to how strong the state's case is, which is weak indeed. It's based on on inferential reasoning from a speculative foundation. He must be the K that's in this telephone call. He must be Fafa as in that telephone call, because his company has banked cash. The cash must have a dubious origin. Because the alleged murderers have banked cash, it must have come from him. But no investigation into his accounts, into their accounts as to where the origin of the money is, into his bank statements as to how his business operates, and he does have a business. The name of the company is there. It's a substantial business. Building an airport, I was quite startled, but a cargo airport in Welkom. I didn't know that one would take anything to Welkom, but it's a real project. So, in paragraph 63 of my heads, I make the point that he has ignored, in the sense that I've described it, the High Court judgment. And in paragraph 64, I make the point that it's exactly the same personal circumstances, exactly the same kind of alleged murder, and he didn't flee. And then paragraph 65, I beg your pardon, is the same point. Then paragraph 66, this is a very important point, and your Lordship would have noticed it in the replying affidavit that we filed, and in the answering affidavit of the state in the bail application. And let me ad-lib it, and it is there in paragraph 66. They describe a contract killing as what you might imagine a contract killing to be. There's a person that wants someone dead. There's a middleman that can provide the killer, and then there's the killer. Presumably the wanter of death communicates with the middleman, who assigns it to the killer. And that's how it works, and that's what they describe. But then in the affidavit, they say that Mr. Molefe is both a middleman and the client, inconsistently, completely. And the magistrate finds, unjustifiably so, that he's a middleman. But the state plead that he's both. Now what that means is that they don't know what their case is, because there's a vast difference in having a prima facie case or a strong, reasonable suspicion in the background that the appellant is involved in these murders because they can prove he's the client, or because they can prove he's the middleman. But when they allege that he's both, they don't know what they're talking about. That's the gravamen of this point. And it's a fundamental point, because really, if you look at the personal circumstances of the accused, bringing bail into disrepute, all the subcategories of Section 64, 6-4 of the Criminal Procedure Act, you will find that he fails on none of those. And this case, his opposition to bail, depends on the strength of the state's case. And the strength of the state's case is not there. So if Judge Ledwaba was right, and in any event, if the pleaded personal circumstances in the bail application in the Alexandra court are right, the only thing that can tip it in any way towards refusing bail could be the strength of the state's case. And that's not strong, as we will demonstrate. Let me say not strong. I'd go further. It's non-existent. It's based on speculation. Then paragraph 67, the court paid some significance. He found it very significant that the appellant had a 20-year-old previous drug-related conviction in the United Kingdom, and it was for possession or import of cannabis. Now, my lord, a 20-year-old previous drug-related conviction is completely irrelevant to the facts of this case. There's murmurings in the background that this has got something to do with drugs, this case. But there's no case made out that it has to do with drugs. And in any event, a 20-year-old conviction in a foreign jurisdiction is completely irrelevant, and yet the magistrate took it into account. Paragraph 66. The court below found that the appellant had a fraud conviction relating to his stay in the United Kingdom. That is completely incorrect. He had a conviction for the importation of cannabis. Now, on that ground alone,
And not firearms.
And-
Not that the appellant has been charged with firearms either in this
But it
matter.
might have
whilst
had- might have some weight
the
to
other
it.
co-accused have.
it was importing cannabis. And yet, so if a judgment is a mathematical formula, which it's not, this is 1 and 1 equals 3. You can't sustainably make a judgment saying, oh, I'm going to deny bail, this man's got a fraud conviction, when he doesn't have one. So that's a fundamental misdirection. Not only do you not have to find that that's a misdirection, but it fortifies the view that you should form in our submission that this magistrate erred, and you're absolutely free to make your own finding. And then paragraph 69, a related point, he found it really concerning. Now, really concerning means I give it significant weight. And what is it? That he had a false Lesotho passport 20 years ago. But the balance of the evidence shows that he had South African passport, and as they became renewed, another passport and another passport. He traveled internationally, inter alia to Hong Kong, and nothing to do with false passports. And he was at home when he was arrested. There's nothing, this is in paragraph 69 of the heads. There's no indication that subsequent to that 20 years ago, he had anything to do with a false passport. He had the issue of a false passport, as we submit there, could only be relevant if the appellant had shown a proclivity to evade justice at all, which might then have needed the use of a passport. He hasn't attempted to evade justice, and as I say, he was at home. Then paragraph 77. The court below found, and should not have found, that the appellant was a member of a so-called syndicate. There was no evidence, I call it insufficient evidence, but in fact no evidence whatsoever that indicated that he was a member of a syndicate. It's just not there. Then the point I've already made, 71, I won't make it again. It relates to there being the court finding there was significance to the fact that cash amounts were made into the appellant's bank accounts. It's a business. Nowadays checks are gone, but there are EFTs, there's cash, those are the two ways, I imagine, of a business taking in money. But there's nothing linked to the cash deposits. There's no investigation of the bank account to show, for example, cash money going out. So, and it's clear, I'm not clear who's paying him the money. If he's the client, which is the one case that the state have, who's paying him cash? If he's the middleman, well, then you could be paid. It's very unusual to run a crime of openly putting cash into your bank account. It's the first place anyone would look. But there's no justification to link whatever cash is paid into the bank account to any crime whatsoever. It is pure speculation. Equally, I make the point somewhere else that his tax return don't line up with the deposits, but that begs the question, you can have drawings from a business which are not income. You can have a flow in and out with loan, directors' loans, all kinds of things. Money flowing out of an account doesn't necessarily accord with taxable income, and the state don't seem to understand the law of taxation. Then paragraph 72, the court should have been more inclined to find that it's highly unlikely that someone operating illegally and receiving cash payments for such illegal activities would make cash deposits into the bank account. It's just not what criminals do. Then paragraph 73, the court errs again. It says the cash deposits were unidentified sources. But there was no investigation as to where the cash deposits came from. The facts show that there were cash deposits into the bank account. That's it. no basis to categorize that as unidentified sources. And this is yet one more error in the reasoning of the magistrate. Then paragraph 75, the court below erred in finding that it had been shown the appellant played a role in the killings, but no such averments were sustainably made by the court. It was not argued by us that because he was not physically present during the deeds, therefore there was no evidence. The court should have found that it was argued and correctly argued that telephone messages or WhatsApp messages referring to K, KT or Fafa had not been shown to be a reference to the appellant. It is shown that some of those alleged killers use K, KT and Fafa, but it's not shown that Katiso Molefe is K, KT or Fafa. And in his replying affidavit, when confronted by this startling allegation, he sets out in detail what people call him. And he's got another name, and it's an entirely rational name in terms of African culture, or his branch of African culture, to have a grandfather with the same name, Katiso, did not allow him to be called Katiso. So everyone gave him a different name. Seliti, I think the name was. And it's an entirely...
The one who waits.
Pardon?
The one who waits.
Yeah. The one who waits to take the name that the grandfather has. Yeah. So it's not one of those bland denials. He says, what? You say people call me K or KT or Fafa. That's not. This is what they call me. And there's nothing to gainsay that. And it's important to know, my Lord, as you will know, that when you bring a bail application, you actually don't know why the state are opposing bail. So you set out everything you think can be relevant. Then, as you saw from the record, twing, they produce an answering affidavit in court, there and then. We stood down for a few days to reply to it. It's not that usual in bail applications that that is done, but we knew that trenchantly we could answer this case in the answering affidavit, and we did so. And yet the magistrate ignored it.
May I say, Mr. that the evidential value, if I understand the law correctly, the evidential value of at a bail application, one can obviously leave viva voce or oral evidence, and one can provide affidavits. One can,
Yes.
can conduct a bail application in that vein or that manner, and thirdly, one can simply make submissions from the bar.
Yes.
And that the acceptability or the weight that can perhaps be placed on those three modes of leading evidence at a bail application decreases as one goes down the list.
Yes.
Yes. So obviously here this court doesn't have the benefit of a record with cross-examination,
Yes.
but that works both ways. So the appellant having elected to follow this route, it was still open to the state to lead viva voce or oral evidence in rebuttal
Indeed.
of the case.
And had they had a strong case which would have survived cross-examination, not as if it were a trial, but just at least a testing of the prima facie strength of the opposition to bail, they could have put that IO, the investigating officer, in the witness box, and she would not have survived cross-examination. I'll give you a succinct example, my Lord, and I'm sure we deal with it in the heads. In the answering affidavit that they say Mr. Molefe travelled to the UK, and they give dates. And it's evident from the record that the investigating officer was in court. She heard the affidavit read out by the prosecutor, which averred travel in January, I think, to the UK. Now, he's banned from going to the UK. He's not allowed to go to the UK. And there was no reaction. From the record, you will have seen that in the intermission, there was a challenge directly to the state. Produce the passport. That's not correct. And then they retracted on record, saying, sorry, we made a statement under oath that he travelled to the UK. It's wrong. In the supplementary affidavit that they file almost at the same time as we file a reply, do they explain how they could possibly make the error that he travelled to the UK in recent times? No. They don't apologise for misleading the court. They don't apologize for the IO not leaping up as the evidence was being put before the court by way of affidavit and saying, hey, that's a mistake. No. They let it settle in the mind of the court. Only when pulled up short by ourselves did they then retract that. Now, Lord...
Mr. Sorry to interrupt again. Just leading out of that, and this is something I wanted to ask you, is that on the question of travel and obviously the implications that to decide whether the appellant is a flight risk or not. If I understand it correctly, the averment was made in the answering affidavit that not only had the, and you've dealt with that now, and I've seen that, and I understand that submission with regards to the United Kingdom, but there was a lengthy, and again I accept the argument that it's not backed up by any documentary evidence, so I don't know where it came from, but be that as it may, there's a submission made by the investigating officer that, putting aside that any travel to the United Kingdom, that there was frequent travel to other destinations. When I say local, I mean within territories adjacent to South Africa, within Africa itself, and overseas, Hong Kong, as you previously mentioned, others. Those are not dealt with in the reply. Am I right? The only item, as it were, that's dealt with is the UK trip, or the
yes,
UK trip.
But because, as I said to the magistrate, if travelling overseas is a bar to getting bail, I doubt that I or any of my colleagues or your lordship would get bail.
No, I certainly would.
You would.
Yes.
Well, I wouldn't. I was in England last week, and don't give me bail. In fact, so worldly are the state, you'll find in the answering affidavit, and I mean this with light sincerity, but still sincerity. So worldly are the state about travelling locally and internationally. They describe Hong Kong as Honk Kong. So a worldly or unworldly wise NPA say, if you travel overseas, well, no, you can't get bail. And that's why it's not dealt with in a replying affidavit. It's entirely normal in the modern day that people travel. And how do you solve that? You take away the passport, you give reporting requirements.
On that, I'm sorry, and I'm jumping ahead.
Yes.
In the event of this court deciding that the appellant should be granted bail for these in respect to these additional counts. Of course, we've now got a count that's going to be consolidated where bail has already been granted.
Yeah.
So I'm not quite sure how that works. But it obviously gets overweighed by the refusal of bail, and should this court not do so. But let's not get caught up in the niceties. That's an aside. But the fact the fact being that there was no in my brother Ledwaba's order and the conditions that he set out, there was nothing dealing with the passport at all.
Yeah.
So we accept now, and again, and I don't want to. We can deal with, if you wish, as a separate argument, this asking for the passport back.
Yeah.
I think that's perhaps a red herring, but obviously I've got to hear
Yes.
Mrs. LaRue and what she says about that. But the point is, if this court should, in its discretion, decide to grant the appellant bail, would the appellant be satisfied, or there's no argument about the passport being surrendered?
Absolutely. The reason why it wasn't in Ledwaba's judgment is because the police already had the passport. I've had many times in my salad days got bail in the magistrate's court, and the condition was that the accused surrender his passport to the investigating officer. Then you come to pay your 10,000 rand bail, and the clerk wants to know, I want to see the passport, I want to see you hand it over. And you said, but the IO's got it already. No, I'm not satisfied. Then you spend the night in jail trying to prove that the IO has already got the passport. So now what I do is I say, don't make it a condition, because the IO's already got the passport. But it doesn't matter which way. To answer your mechanical question, if that's what it is, there's no order to that effect in the Ledwaba judgment. But if you gave bail, you could make it an order that the passport remain in the possession of, and remain in the possession of solves my problem with the clerk or the registrar of the court remain.
So what is the factual position? Is it common cause? Then
Yes, the IO has got it.
has it.
That's how we brought them to heel on the question of him travelling. In the adjournment, we said, show us the passport. There will be no stamp to the UK, and then there was the retraction. So the IO has it, as opposed to the I's have it. Right, then paragraph, just let me deal with something tangentially raised by Your Lordship, and that is that in the battle of weight of evidence, the state and the accused are at the same level. So the state could have led viva voce, they didn't. You can't hold it against the accused for going on affidavit. The state also went on affidavit. So you've got to judge the internal worth of the affidavits regarding them as equal in weight.
And what can you refer the court to any the entire criticism of the respondent's case is that there's this wild speculation, but nothing. Do you have any decisions other than I could only find a reference to Van den Berg bail again, and perhaps the what is it? And the decision of the Jacobs unreported decision. But do you have anything that's clearly on point in that regard?
Not really.
That would seem to be the crux of the.
Not really directly in point, but from common law principles in the law of evidence, something only has weight as evidence underlined in inverted commas, if it is truly evidence, if it is inferential reasoning from proven facts, with the underlying proven facts being indeed proven, and the inference being a reasonable inference. So that is State versus Blom, that is fundamental law of evidence. So I don't think you would find authority for that, because it's so down to the basics of basic. But my learned Mr. Joubert points out that even in the Lomas case, which we annexed in the low court, that court found that there was an overwhelmingly strong case against this individual, Mr. Lomas. He was heading for 15 years imprisonment. But that bail was not a pre-conviction sentencing procedure to hold him bound until he inevitably went to jail for 15 years. So he was released on bail. In that instance, he was frail and he had all kinds of maladies. But the essential opposition to bail was he's going to jail for 15 years. And Judge Stradom said, well, maybe he is, but this is not then, this is now. So let him go out on bail, and all kinds of procedures to make sure he doesn't run away. And there was no indication that he would run away. But this is not sentence, this is bail. On the passport issue, you'll find in paragraph 66 of the replying affidavit, he says, I do not have a Lesotho passport. At present, I've never again had a Lesotho passport after 2004. I only had one passport, which is the travel document mentioned in paragraph 33 of Exhibit A, which is his filing affidavit for bail, which is in the possession of the investigating officer. And that is not countervailed by the state in any way. Then, my Lord, paragraph 75, we say that the court should have found, and this court should found, that the appellant had established an overwhelming probability that the state would be unable to show that he, by means of incorrect inferences drawn from the WhatsApp messages or telephone messages, was KT or Fafa. Then I make the point, which I think I've made, the state is drawing inferences from speculation, which was merely that. You cannot reach a sustainable inferential reasoning conclusion from a basis of speculation. And we say that we demonstrated that the state's case was weak. Then paragraph 78, the magistrate says, it was quite apparent that the gunmen were awaiting payment from the applicant for the hits performed. There is no such sustainable evidence that he had engaged anyone, that he was engaged, that they were engaged by him to perform hits. It should be clear that if the state possessed any convincing and conclusive evidence, they would have produced same and not relied on speculation. Indeed, gone into the witness box, that cauldron of the test of truth, at least on this prima facie basis, to say, well, investigating officer, what do you indeed have? Then he finds, so does the magistrate, and so should you not find, that it is significant that the phones of accused 1 and 2, these are the alleged hitmen, were picked up at a cell phone tower near the appellant's house on a day in November. But we show that the appellant lives in Sandhurst. I wish I lived there. It's an exclusive suburb right next to Sandton. There must be thousands, hundreds of thousands of people whose phones pass through that area. There's nothing specific to his house, and there's something very unspecific to Sandton. And yet it's a straw which the drowning man of the state clutches in order to save itself. I've already argued there can be no connection between the accused 1 and 2, the alleged hitmen, and 3, depositing cash into their bank account. They may have been depositing cash, but there's no withdrawing of cash. There's nothing to link except speculation that the one has anything to do with the other. Then the court finds, paragraph 81, that someone living in Roodepoort or Attridgeville, Pretoria, should not be in Sandton. Sandton is the central place of Gauteng, apart perhaps from aspects of Pretoria. And in any event, the foundation of the founding affidavit shows that accused Tau, however he may have gone wrong in his life, was an old acquaintance of the accused. We go into extreme lengths, not distancing ourselves from Tau, but saying, but we know the man. So it shouldn't have been found to have been significant that on a number of occasions he tried to phone, and many occasions didn't get through. There's simply no connection between Tau, the friend, and Tau, the killer, with, or the alleged killer, with Molefe. And paragraph 82, it's the same argument. The court found it significant that Tau was phoning him, but we've explained he was a friend. Again, 83, it's really the same point, but the logic of the notice of appeal follows the reasoning of the magistrate. So he takes this into account a second time. And we criticize the inference that the cash deposits into the other accused's bank accounts were related to money flowing from the appellant. It's blatant speculation. There's no underpinning factual evidence. And we make the point in paragraph 83 as to why that's a good point. Then the court erred in finding that the appellant made several assurances regarding the previous bail application of accused 1. In fact, he was giving no assurance whatsoever. And it wasn't his wife that he made the assurance to. It was the girlfriend who sent something to him. And it should have been found to be unremarkable that the appellant was interested, even through someone else, in the fate of a friend's bail application. So in finding that on 2 August 24, the appellant sent a WhatsApp message relating to the bail application of accused number 1, the court didn't take into account the evidence of the appellant that he doesn't use emojis, and that if an emoji appeared on his phone, it would have been something that he forwarded. So someone sent something to him, not he sending someone else. And at best, it was something that he forwarded. And then paragraph 85 of our heads, that's the point I've already made repeatedly.
Yes.
and 86. And then 87, there is no allegation that the evidential link between the four accused appears to have increased. All we have is the speculation that I've dealt with, KT, FAFA, cash deposits, all of them carrying no weight whatsoever, or the weight of a feather. Paragraph 88 is a point I've already made. '89 is a point I've already made. Since given bail, facing a life imprisonment, potentially, he was at home. Then paragraph 89, Your Lordship will see in the authorities that we've quoted. Firstly, the High Court found exceptional circumstances exist, and we must acknowledge Section 6011 requires the accused in these circumstances where he's facing premeditated murder to establish exceptional circumstances. But the balance of the law is that you don't have to be exceptional, but if to an exceptional degree, a very good high degree, you establish the ordinary test for bail. And in our founding affidavit, we analyze the test in Section 6I4 and 6I9. We satisfy all the tests, and we show that the interests of justice demand that we be released on bail. Now, if you satisfy, and the case is Vankwa, if you satisfy everything to a high degree, that's exceptional. It's like being an exceptionally good human being. So there's been much debate about what this exceptional circumstances means in law. And Judge Krichler, as he then was, said, well, you know, the courts will interpret it, but I'm not going to interfere with its constitutionality. But the balance of the wisdom in the cases that we've quoted says that if you establish to an exceptional degree all the circumstances normally entitle you to bail, those are exceptional circumstances, and we suggest Your Lordship should find that. Then paragraph 91, the last misdirection of the many. The court below should not have found, as there was no evidence before the court to this effect, that the appellant had a circle of influence and capabilities. There was not an iota of evidence to that effect, not even speculation to that effect. No capabilities of any relevance were proved, no circle of influence was proved, so the court should have found. Now, in the few minutes remaining, my Lord, I think we started slightly before 2 o'clock, but I'll regard 45 minutes as 2:45, if I may. We start on the law, starts with the Constitution, and I don't want to sound like a first-year advocate, but it remains the foundation stone of how you will approach it. He's allowed to be released. This is a democratic, constitutional state, but there are brakes on being released. And let's look whether those brakes kick in. And we say, as in the Lomas case, that those brakes have not kicked in. So if you go to paragraph 93, my underlining, the proper administration of justice should never be seen as favoritism towards persons charged with serious crime, but rather as a basic and necessary protection of an orderly society governed by the rule of law as encoded in our Constitution. So the Bill of Rights allows us to be released from detention if the interests of justice permit, subject to reasonable conditions. Then we go through the Constitutional Court, Dlamini, Shlajla, etc., and eventually we get to cases such as Vankwa, which you'll find in page 104, and Van der Berg, to the extent that he is a learned author, which he is, relies on this very heavily in the balance of his book. Circumstances of an ordinary nature to bail applications can, in the context of a particular case, be exceptional or unusual. And then, as Krichler J. says, Section 6011 does not contain an outright ban on bail in relation to certain offences, but leaves the particular circumstances of each case to be considered by the presiding officer. The ability to consider the circumstances of each case affords flexibility that diminishes the overall impact of the provision. What is of importance is that the grant or refusal of bail is under judicial control, your Lordship's control, and judicial officers have the ultimate decision as to whether or not, in the circumstances of a particular case, bail should be granted. And then in the Siwela case, page 106, the point that we underline, I do not believe that it could have been the intention of the legislature when it enacted Section 6011 to legitimize the at-random incarceration of persons who are suspected of having committed Schedule 6 offences, who, after all, must be regarded as innocent until proven guilty. And then further in 107, if the state was serious with its opposition to the granting of bail, it should have led rebutting evidence, at least placing in dispute the uncontested evidence of the appellant. And you'll recall, my Lord, they didn't give viva voce. The affidavit evidence is of equal weight on both sides. There's a lack of content in the answering and even in the supplementary. And as the quote says, placing in dispute in this sense postulates a genuine dispute. Mere accusations are not enough. And those Mr. K and Mr. KT are mere accusations.
Here you are, Mr. So when I asked earlier for a case on point, I think this is it. So.
It is actually. It is. Your Lordship is quite correct. But it's what I said as well. We're not remembering I quoted this case. Yeah. Well, Lord, I think my time is up. But in essence, this is in a nutshell. Judge Ledwaba gave him bail on exactly the same personal circumstances, facing premeditated. Found it's exceptional. There are further charges of premeditated murder. The circumstances remain the same. The opposition to bail is weighted on the strength having a state's case, a strong case. The state have not demonstrated a strong case. Cash, WhatsApp messages, cell phone towers. If we were facing a discharge application, and the tests are entirely different, but just imagine for a moment that was the case against the state. There would be a 174. There's just speculation. There's no concrete evidence. Although that's not the test, it's just a way of approaching the matter. Then, my Lord, my time is up. I would urge your Lordship to, if you have to, once again have regard to the balance of the heads of argument, and obviously the answering and replying affidavits in the context of the founding and replying affidavits in the context of the answer. And you will find that we've established to an exceptional degree, underpinned by previous judicial judgment, the right to bail on the basis of having established exceptional circumstances. Thank you.
Thank you, Mr. Evans. Yes, Mr. Lulu.
Thank you, my Lord. My Lord, let me start off by stating that as we relied previously on Matibula, the case is included in the bundle, as your Lordship knows, that it is not now to establish exactly what is the strength of the state's case. It is but one of the factors that this court needs to take into account. And as in Matibula, clearly where the judge indicated that even if the case seems to be frail at bail stage, that should not be the overriding factor. I want to include here, my Lord, a decision which I did not include in my head. I actually just in my preparation came across this decision, and that is the state, Isaacs versus the state, and that is a matter that deals with circumstantial evidence. My Lord, I'm going to hand it up, and I've got a copy here for my learned friends also. And this is actually one paragraph that I want to refer the court to.
Thank you.
If I may, Your Lordship, if Your Lordship can go to page 18, paragraph 61, where the court there deals with how circumstantial evidence should be evaluated. and the last sentence there that reads as follows: the state must satisfy the court not that each separate item of evidence is inconsistent with the innocence of the accused, but only that the evidence taken as a whole is beyond a reasonable doubt inconsistent with such innocence. Now, my lord, my learned friend went to great lengths to evaluate the circumstantial evidence that the state has against the appellant in isolation with each little fact. But I would like to propose to this court that if one has a look at the picture that the state tried to paint specifically in the answering affidavit and the later supplementary affidavit, the picture that emerges is more than just the single bits of evidence. And it is so that the state has been criticized for apparently not being consistent in its description of the appellant's role in these killings. The fact is, and I concede that in the circumstances it may have been an unfortunate choice of words to also refer to him as a middleman. But the fact of the matter is, the point that the state made in its paragraph 9.3, and I'm going to get my hand on it just now, if I can just refer the court to the answering affidavit, which starts at 004, baseline 63, and I'm going to just take the court to that specific paragraph. Starts at 00463, my lord. The answering affidavit. And more specifically, paragraph 9.13, where the term of middleman is used, for which we've been heavily criticized. Paragraph, page 00471.
Yes.
The point, the gist of paragraph 19.30 that the state wanted to drive home here is that the person that is not on the scene, that's not the gunman, that person is in the background and never on the scene. And the evidence against the appellant should be evaluated in that context. You will never find in any of these cases an indication that there's DNA or that there's ballistics that link the appellant. It is because of his exact role as the person that orders the hit. He gets someone else to do the dirty work. So the court will also, as the court works through the transcript and the various affidavits, will notice that the case against the gunman is much stronger. It's much stronger. So the state relies then on cell phone communication, which then paints a specific picture. My lord, and I would still submit that the case for the state, that the accused is indeed Paffa, is at this stage the strong point that the state makes.
So on that point, and I recall, and you'll bear with me, obviously I've had a fair amount of reading to do at a very late stage, but there is a reference in the affidavit, and I'm not sure whether it's the reply or potentially the supplementary. There's a reference to that specifically to say, well, this is why, and there's the name, Puffer. What documentary evidence, is there documentary evidence to support that?
Yes, my lord.
Let me just, if you...
If your lordship will go to the supplementary affidavit, which is Exhibit D, and it starts at 004187, and I'll take the court to that portion now. The supplementary starts there, and then it has several annexures, which I noted some of them as had the photograph copy, but the specific reference to that cell phone download was attached to the state's documents. My Lord, I'm referring to HM9, to the document, to the supplementary. I will put my hand on it right now.
Thank you.
So HM9, my Lord, can be found on 004-192. This is a download that was made from the cell phone of the appellant. And that is a message that he received on the 25th of December 2023 as a Christmas greeting, where a certain person by the name of Tepsa refers to him as Papa. In the very first line of that page, the court can see there, Merry Christmas, Sympathy, Mokobong, and then in brackets, Papa.
All right, thank you. That answers that, because I wasn't sure
Yes.
when I read the affidavit whether the puffer in brackets was a reference by the deponent, or whether in fact that is what the text read. So that answers the question.
That's how the
Thank
appellant
you.
received the message.
Yes.
So, my Lord, and the defense will probably in reply say that there's no indication that the appellant is Papa. The fact of the matter is that name appears on his cell phone as a message that he received. And what we then see in the communications, specifically with regard to the DJ Somebody killing, and also the DJ Vintos killing, where constantly reference is made to Papa after the killing as being